Good morning, friends, my dear colleagues in legal profession, and also the concerned democratic and civil liberties groups friends. Recently, former Chief Justice of India, DY.CHANDRACHUD, has stoked a controversy by disowning his own judgment in Ayodhya dispute. On that issue, I have analyzed how the way the things are going on for him. Under the title, Justice DY.CHANDRACHUD, from liberal icon to controversial legacy. Friends, former Chief Justice of India DY.CHANDRACHUD has stoked a controversy on the Ayodhya dispute with his remark that the very erection of Babri Masjid was the fundamental act of discretion. In a recent interview with news laundry journalist Sr.Adv, Justice DY.CHANDRACHUD's judicial journey has been marked by sharp contrasts. Before becoming Chief Justice of India, he had built a reputation as a liberal judge. Landmark rulings advanced the constitutional values of dignity, liberty, and autonomy, recognizing the privacy as a fundamental right, allowing women entry into the Sabarimala temple, decriminalizing homosexuality and adultery, affirming a woman's choice in marriage, and in notable dissent judgments questioning the arrest of activists in the Bhima Koregaon case, opposing Aadhaar Act's passage as a money bill. These judgments earned him praise as a defender of the constitutional freedoms. Yet his record was not without blemishes. He dismissed the demands for an inquiry into the suspicious death of Judge Loya, who had been hearing a fake encounter case involving Amit Shah, now Union Home Minister. He was also a part of five-judge bench that delivered the Ayodhya land dispute verdict, which, though carefully worded, effectively tilted towards majoritarian sentiments. His appointment as Chief Justice of India, however, belied his earlier liberal career. Expectations were high that his court would stand up to a domineering Modi-led government. Instead, the Chandrachud court delivered a series of questionable decisions and orders that often appeared to rubber stamp the executive actions while failing to contain the overreach by the ruling party government. In a key instances, for example, the Maharashtra Shiva Sena defection case, the Delhi government versus Lieutenant Governor case, the Ganvapi Mosque survey, and upholding the abrogation of Article 370, the court's judgments either favored the government or permitted controversial actions. Allegations of inaction or delays also marred his tenure. The court deferred crucial cases involving Umar Khalid bail case, the speaker's inaction in disqualifying the defectors in Maharashtra, the Pegasus spyware case, and he also refused to order investigations into the allegations of stock manipulation by the Adani Group. As a master of the roster, Chandrachud often allocated cases in ways that favored the government, either by assigning sympathetic benches or postponing hearings indefinitely. The contradictions became even starker after his recent interview with News Laundry, and where he described the very erection of Babri Masjid as a fundamental act of desecration. This statement contradicts the unanimous Ayodhya judgment he co-authored, which explicitly recorded that no evidence proved a temple was demolished to construct the mosque. Why would a former Chief Justice disown the findings of his own judgment? His observations reflect an unmistakable fidelity to the core ideological standpoint of Hindutva of Rashtriya Swayamsevak Sangh and its political arm, the Bharatiya Janata Party. It is this same ideological reasoning that also led him to allow the survey of the Gyanvapi Mosque in Varanasi, despite the unambiguous prohibitions of the 1991 Places of Worship Act. In fact, 1004 1045-page judgment of Ayodhya dispute, on the title dispute, the bench said no evidence is available in case of this antiquity on the cause of destruction of the underlying structure, whether the pre-existing structure was demolished for the construction of the mosque, and ultimately the Supreme Court bench relied on the principles of possession and balance of preponderance of probabilities. If Justice Chandrachud had strong beliefs about the Ayodhya issue, then he should have recused himself from the matter, saying that he cannot take an objective view on this matter, and because he believed that the construction of Babri Masjid itself is a desecration, did Justice Chandrachud, a noted jurist, have the necessary judicial integrity of being transparent about these things, being a co-author of the Ayodhya judgment? These remarks raised troubling questions. By echoing Hindutva rhetoric, Chandrachud appears to be seeking political approval, potentially paving the way for post-retirement rewards. Commonly we call that quid pro quo judgments, similar to the cases of Justice Ranjan Gogoi and Abdul Nazir. The contrast with his father, late Justice Y.V. Chandrachud, is striking. The elder Chandrachud, who also served as Chief Justice of India from 1978 to 1985, is remembered for his principled stand on constitutional values and resistance to the communal or authoritarian pressures. The son, occupying the same high office, risks being remembered not for courage or fidelity to the Constitution, but for compromise, inconsistency, and covert alignment with the power. The office of the Chief Justice of India is meant to be the guardian of constitutional morality, the final safeguard against the authoritarian overreach by the government. By contradicting his own judgments, delaying crucial issues, and pandering to the political narratives, Justice D.Y. Chandrachud has weakened public confidence in the higher judiciary and done a disservice to the Constitution he once led. What is the conclusion? India does not need judges seeking political approval or post-retirement rehabilitation or rewards. It needs judges who look only to the Constitution. By falling short of that standard, Justice Chandrachud risks leaving behind a legacy of opportunism rather than judicial courage. This is very regrettable. Thank you. Jai Bharat, Jai Constitution.